Hi, this video will provide an introduction to patents. An inventor invents something. For example, Amazon has many patents on their drone technology. An inventor wants to take ownership of the invention and not allow anyone else the right to make the same invention. In order to protect the invention, a person or their company files a patent application. Patents are what's considered a negative right, which means that you can't copy a patented invention, you can't make the invention, you can't sell the invention, or import the invention unless you're the owner of the invention. An example of an invention is a computer mouse. A patent application has to be filed at the U.S. Patent and Trademark Office. Now, there are a few things that you should not do before you file your patent application. For example, selling your product or offering your product for sale is a no-no before filing a patent application. Making your idea publicly available, for example, presenting at a conference or putting in a poster that's publicly available, publishing your idea in a paper, or publishing your idea on a website is a no-no before filing a patent application. You shouldn't use your product publicly, which is called public use. If you use it as an experimental use, then this rule doesn't apply. And another thing that you shouldn't do before filing a patent application is actually abandon your invention. What this means is if you start working on your invention and then stop pursuing it for a prolonged period of time without any valid reason for doing that. If you do number 1, number 2, and or number 3, it starts a 1-year clock in the U.S. You then have to file a patent application within that year. If you don't, you lose all rights in your idea. So first, an inventor comes up with an idea or an invention. Then a patent attorney drafts a patent application and files a patent application with the United States Patent and Trademark Office. Now, things to keep in mind. Performing a search of your idea isn't required before filing a patent application. However, it is probably a good idea to do so. You should do this to determine what else is out there and if there's anything that's similar to your idea. And this will allow you to determine whether it makes sense for you to go forward with filing of a patent application. There are several ways to do a search on your idea before filing a patent application. For example, you can just go on your internet browser and do a search of your idea. You can do a search for issued patents and or published patent applications by going to the USPTO website and do a search for patents, as stated in the PowerPoint presentation. The search should encompass anything in the public domain, including the U.S. and outside the U.S., because anything that's in the public domain can be considered prior art to your invention. Now, there are 4 main types of patent applications in the U.S. These are the provisional patent application, the utility patent application, a design patent application, and a PCT, Patent Cooperation Treaty application. A provisional patent application is a placeholder patent application, which gives you a filing date. A provisional patent application must be converted into a utility patent application on or before its 1-year anniversary. If the 1-year anniversary ends on a weekend or holiday, you can file the utility patent application on the next business day. If you don't decide to convert your provisional patent application into a utility patent application by the 1-year anniversary date, it expires and remains unknown. It doesn't publish and no one will know that you filed it. The provisional patent application can take any format, include any type of drawings, and it does not get examined by the U.S. Patent and Trademark Office. Again, it's a placeholder for what's to follow. If you file a provisional patent application, however, you can write patent pending. Now, utility patent applications include several parts and will be examined by the United States Patent and Trademark Office. The main parts of a utility application are the specification, the figures, the claims, and the abstract. The drafter of the patent application is his or her own lexicographer. This means the patent drafter can invent and or define terms that he or she uses. But we'll discuss this in more detail soon. A design patent application is granted to a person who has invented a new, original, and ornamental design for an article. An article includes manufactured items such as tools, jewelry, computer monitors, printers, and even icons or software screens. For example, a web page displayed on a computer monitor can be filed as a design patent application. Protects the ornamental and non-functional design of the article and not the article's utility or use. If the design is functional, then only a utility patent application is needed. It's relatively inexpensive to prepare a design patent application, as it only includes one or more drawings and one claim referring to the drawings. It could be very valuable to file a design patent application and can potentially huge money in litigation. Now, a PCT or Patent Cooperation Treaty application is a very expensive application to file, but it covers an international basis, and it's a placeholder application for filing later applications in foreign jurisdictions. You must file your PCT application within 1 year of your earliest U.S. filing date, so either your utility or your provisional filing date. A year later, you must file a PCT if you decide to proceed that way. So let's get more into utility patent applications. The parts of the specification. So the specifications actually do the description of your invention. It includes usually a short background section, a summary of your invention, a brief description of any drawings that you may include, a detailed description of your invention, a claim section, and then the drawings themselves. Once you file your patent application, after a period of time, the patent office examiner will review your application and send you what's called an office action, which is a document in which the examiner typically rejects your application. They usually state that the application is not patentable, and it's your job and your attorney's job to respond to the patent office with a written argument, with arguments stating why your application is patentable. Now, you can't really change your application specification once it's filed, but what you can change are the claims of the application. The claims are the legal rights to your invention, and they're words that describe and embody your invention. Well, after one or more multiple rounds of arguing with the USPTO examiner, you either obtain a patent or over time you may decide to abandon the application if you don't think your claim scope will be valuable. Issued patents are legal rights for 20 years, as long as you pay maintenance fees. And then they expire. After your patent expires, after 20 years, they're basically available for free to anyone to implement. Design patents are legal rights for 14 years from issuance. There are a few exceptions to this rule, but that's generally the case. Okay, so get ready for artificial intelligence. It's coming, or it's already here. Companies are filing patent applications on robots and machines that use artificial intelligence. So now we're going to go through an introduction to trademarks. A trademark or mark is always attached to commercial activity. Trademarks are one or more words, names, graphics, logos, slogans, sounds, colors, and or scents that identify a source or origin of a product, good, or service. To qualify as a trademark, it must be used by a business in its marketing and must be distinctive enough to gain customer recognition on its own, which is called inherent distinctiveness, or have earned customer recognition through continued use over time. This is available only for descriptive marks called acquired distinctiveness or secondary meaning. Rights to a trademark are given solely through priority of use or an intent to use trademark application. Trademark ownership is determined by the person or entity that uses the mark in a commercial setting first. Trademark law protects both sellers and purchasers, and the typical time it takes to federally register a trademark is between 8 and 10 months. There are two ways to qualify as a first user of a trademark, and they are actual use or intent to use. The PTO keeps two lists of trademarks that it registers: the principal register and the supplement register. Thank you for listening to our video. I hope it was informative. Bye-bye.